prosecutor has the ability to confer active production immunity. Well, what does that mean? And so let's back up a little bit and let's set the stage. The government really wants the stuff, but under Fisher, the very act of turning it over is incriminating. The government could theoretically grant the taxpayer immunity with respect to the act of production. And what does that mean? Well, the government, if they offered active production immunity to your client, wouldn't be able to use the fact that he turned the documents over in response to a subpoena or a summons to authenticate the documents. So let's back up even further. Whenever the government in a criminal case is seeking to introduce documents, there has to be some form of authentication. They can't randomly and arbitrarily introduce evidence without authenticating it. And the same holds true when the information was the same, especially, I should say, holds true when the information that they are seeking to introduce into evidence comes from the defendant, him or herself. What the active production immunity does to the client is it prohibits the government from telling the jury that this information that they're introducing came from the defendant and that he or she was the one that provided it to us. They can't use that to authenticate the evidence, which are mainly going to be documents or something of the sort. So they can't use the defendant to vouch for the fact that the information is authentic and that it's responsive. So if the government grants a taxpayer active production immunity, how then will it authenticate them at trial? Authentication can be boiled down to two essential ingredients. That's possession and production. So in this example, let's suppose that the taxpayer owns a corporation and the government wants to introduce documents that it obtained from the corporation in response to a subpoena. How would the government show that the corporation possessed the documents requested by the subpoena and produced them in response to the subpoena? If you think of chain of custody and how the government can establish a chain of custody, it becomes a little bit easier to distill. The government can call two essential witnesses into court to testify to overcome this issue of being unable to blatantly tell the jury or blatantly authenticate the documents through the defendant. They can first rely on the process server who delivered the subpoena to the corporation, and second, the individual within the corporation who received the subpoena. In this case, the custodian of records. So the government can basically overcome the authentication hurdle when it grants active production immunity to the defendant by calling these two essential witnesses into court to authenticate the information. The jury will then have to infer from this testimony that the corporation possessed the records and that it produced them in response to the subpoena. This is the case of Broswell versus U.S. In this case, the issue was whether the custodian of records could claim the privilege under the active production doctrine on the grounds that his active production would be personally incriminating. And the example here is, what if the taxpayer is the sole shareholder of the corporation? Because many times we're representing a taxpayer who, but for the fact that there is a corporation, essentially is the corporation because it's a small-held corporation, maybe even a family corporation where there are but a few employees. And, for all intents and purposes, the client is the corporation and is the face of the corporation. And he or she may wear all the hats in the company, from marketing to promotion to product development to public relations to even being the custodian of records. So in this case, that was exactly what was going on. And the defendant made the argument that any production by the corporation would be viewed by the jury as having been done by me, the company's alter ego. But the court held no. how does all this apply to foreign bank account records? Well, what we're going to do is chat a little bit about the Bank Secrecy Act, because we want to have a basic and fundamental understanding of the Bank Secrecy Act so we can understand how this all relates to foreign bank account records. The BSA, for short, requires taxpayers to annually report to the IRS foreign financial accounts in which the taxpayer has a financial interest or signatory authority. This information, as many of you are aware, is reported to the IRS on what has become known as the FBAR, the Report of Foreign Bank Accounts. It's also known in tax lingo as FinCEN Form 114. It's actually not an IRS form, it is a FinCEN form, and so it has to be processed electronically. That's one of the differences between that form and other IRS international reporting forms. But what's interesting here is, just a side note, the Bank Secrecy Act was passed back in the 70s. And believe it or not, the FBAR was actually a part of the original Bank Secrecy Act. So a lot of people wonder, why is it that the FBAR has only really come into fashion and has only really become, has only really become enforced, since 2001, because between 1977 and 2001, while this FBAR requirement was on the books in the Bank Secrecy Act, it was never enforced. I mean, that's why people had, money offshore and, and didn't think twice of having any requirement or obligation, and never filed an FBAR, even though it was part of the original Bank Secrecy Act. As many of you are, your minds are working quick, and you've probably guessed, 9/11 was what caused the FBAR to become in vogue and to become an essential tool in the government's fight against terrorism. It also conveniently became an essential tool for the government to refill the coffers of the Treasury, because the government realized that so much money was parked overseas among U.S. citizens and residents, and that the FBAR requiring disclosure of that would lead to sizable penalties for those taxpayers who were out of compliance. So the government became very aggressive in using it as an enforcement tool to combat terrorism, as well as to refill the coffers of the U.S. Treasury. So in addition to the reporting requirement, the FBAR reporting requirement, the Bank Secrecy Act also requires taxpayers to maintain for a period of 5 years records for each foreign account, including the following: the name in which each account is maintained, the number or other designation of such account. Third, the name and address of the foreign bank or other person with whom the account is maintained. Fourth, the type of the account. And fifth, the maximum value of the account during the reporting period. So these are the 5 main things that are required in addition to the FBAR reporting requirement. The regulations don't articulate how to compute the 5-year retention period, but it is generally agreed that the 5-year period is calculated by reference to the current year, not by reference to the year under audit. So let's say, for example, that the IRS issued a summons back on November 1st, 2016. The Bank Secrecy Act would require the taxpayer to only maintain records concerning the foreign bank accounts retroactively from November 1st, 2011. This becomes a tempest in a tea kettle, if I'm using that expression correctly, because a lot of taxpayers who are entering the Offshore Voluntary Disclosure Program, which is labeled by the acronym OVDP. It's a voluntary disclosure program that essentially offers immunity to taxpayers who have failed to report their foreign bank accounts over a lengthy period of time, one that was very pervasive and where the bank accounts' high watermark values were substantial. They have to go back 8 years in time to report their foreign bank accounts and for the voluntary disclosure. And a lot of times the examiner while they are conducting what's called the certification of the offshore voluntary disclosure, will require documents that go back more than 5 years in time to verify the claims that are made by the taxpayer in the offshore voluntary disclosure submission. And this is a problem because the Bank Secrecy Act only requires the look-back period to be 5 years. The OVDP period is actually 8 years. So you can imagine a situation, and this is one that I recently had, where the examining agent is actually requesting information that goes back more than 5 years in time because of the look-back period being 8 years. Now, no question that the taxpayer has to sign what is called the extension of the statute of limitations on assessment whenever they enter the offshore voluntary disclosure program, but that is separate and apart from the Bank Secrecy Act requirements. So in some cases, the IRS is looking for a needle in a haystack for, like a foreign account statement that dates back to 8 years ago, and you can't produce it. And in some cases, in the offshore voluntary disclosure program, the revenue officer is demanding it and refuses to certify the submission until he or she has received that document. But lo and behold, the bank may have changed hands 6 or 7 times since that time, and the taxpayer has made good faith efforts to obtain the document but simply can't. Raising the Bank Secrecy Act 5-year retention period doesn't hold water in a voluntary disclosure case because the voluntary disclosure program has its own rules and regulations. But just a side note on the 5-year retention period and how it doesn't apply in cases of voluntary disclosure. So the required records doctrine has been extended to the documents required to be maintained under the Bank Secrecy Act. But hold on a minute. The Fifth Amendment only protects individuals from compelled testimony. So we have what's called a required records exception. The Court of Appeals for the Ninth Circuit was the first appellate court to weigh in on this. It decided that the Fifth Amendment privilege against self-incrimination could be raised in response to a subpoena demanding the production of offshore bank account records. So this is actually the ray of light, or the light at the end of the tunnel, that opened up for taxpayers who were in the uncomfortable position of having been issued a subpoena demanding their offshore bank account records. This Ninth Circuit Court of Appeals opinion extended the Fifth Amendment privilege against self-incrimination to offshore bank account records. And this was the case in Re MH. You can look it up. It is very easily accessible, even by a search on Google. It was decided in 2011. The Ninth Circuit Court of Appeals held that the records sought through the subpoena fell under the required records exception, and the Fifth Amendment privilege didn't apply. So that was actually the first case. And in other words, the Ninth Circuit held that the required records exception under the Fifth Amendment defense useless. They rendered it useless in BSA cases. So far, the Court of Appeals for the First, Second, Third, Fourth, Fifth, Seventh, Ninth, and 11th Circuits have agreed that the required records exception requires taxpayers to produce foreign financial account information required to be kept under the Bank Secrecy Act. Now, the IRS and the U.S. Department of Justice have issued summonses and grand jury subpoenas seeking information required to be kept under the BSA. And there's been an inordinate amount of litigation surrounding whether and the extent to which these documents must be produced. So this is the case that I was getting to, and I'm sorry, I might have confused the case that I discussed before. So I just want to go back for a second to correct myself. In re MH, going back to 2011, was not the case that actually was the ray of light shining through for taxpayers with offshore bank accounts that had been issued subpoenas. This case, as I just mentioned, was one where the Court of Appeals held that the records sought fell under the required records exception and the Fifth Amendment did not apply. However, when we fast forward to a more recent case, this is the Greenfield case. This was the ray of light that I'm talking about. I apologize. The Court of Appeals for the Second Circuit in New York narrowed the scope of the required records exception as it applies to alleged BSA violations. Again, with BSA, we're dealing with required records retention for a look-back period of 5 years. In Greenfield, the IRS, and this is just a brief recitation of the facts, the IRS learned that Stephen was involved with certain nefarious offshore entities used to evade U.S. tax. Unfortunately, 2005 was the unlucky year for Mr. Greenfield. The IRS selected his 2005 federal income tax return for audit. In 2013, the IRS issued an IDR. That simply stands for Information Document Request, and a summons. So they issued both an IDR and a summons directing him to produce documents relating to both his domestic and foreign bank accounts, including, and here you'll pick up on how broad this was, every account over which Stephen had signature authority and or over which Stephen exercised control during tax years 01 through 11. Right then and there, you can smell that this is a fishing expedition. Even mathematically and linguistically challenged readers can surmise that this request goes well beyond the 5-year foreign account BSA records requirement. To add insult to injury, the summons further requested Greenfield to produce all documents in his possession for each bank account. So they were essentially saying, let's go back to time immemorial and ask for all of the documents that you have in your possession. Greenfield refused to comply with the summons, objecting on the grounds that it was overbroad. The government brought an enforcement action in 2014. Greenfield responded with a motion to quash the summons, arguing that compelled production of the documents sought would violate his Fifth Amendment privilege against self-incrimination. Now, the United States District Court in this case, interestingly enough, they sided with the government, and by doing so, they enforced the summons and ordered Greenfield to produce the requested foreign bank account information. Greenfield, in turn, appealed the decision to the Second Circuit. The Second Circuit reversed the Southern District of New York's order requiring Greenfield to produce the records. In a sweeping decision, the Court of Appeals held that turning over anything other than the narrow set of documents covered by the required records exception violated Greenfield's Fifth Amendment rights, and the documents requested were deemed outside the scope of the required records exception to the Fifth Amendment's active production doctrine. The court reasoned, and what I love about this reasoning and analysis is that it's very practical. The court acknowledged that it was not reasonable to infer that a taxpayer was in possession of documents pertaining to foreign bank accounts that preceded the BSA's 5-year record-keeping requirement. Specifically, it noted that more than a decade had passed since Greenfield was known to be in possession of certain documents. So for this reason, Greenfield is pay dirt for taxpayers who are undergoing a summons in respect to their foreign accounts. And what you want to do here is perhaps envision a scenario where your client receives an information document request or a summons from the IRS. seeking foreign bank account information. In addition to being incredibly broad, the subpoena language might be vague as to what the IRS does and doesn't already have. Those two things are great for issue spotting when greenfield can be argued. The fact that the fact that a broad request for foreign bank account information is being requested, one that mirrors the language in greenfield, which I'm going to go back and just highlight. Every account over which greenfield had signature authority, that unmistakably is an overbroad request indicating a fishing expedition. And second, that the language is very vague as to what the IRS does and does not already have. In those cases, your gut should tell you that something isn't right, and that's when greenfield can be called to action. Should you object to the IDR or summons citing greenfield? Absolutely. And the benefits of this is that the greenfield decision has rippling effects for offshore audits. IDRs and summonses in many offshore audits have finally met their match. As I've described before, in many instances, these IDRs and summonses are nothing more than a fishing expedition in which the revenue agent has incomplete and potentially inaccurate information and is simply looking, or not simply, but is looking for the taxpayer to provide the missing link to a shoddy investigation in order to solve the crime. And that's why we as attorneys must always be on the lookout for when it doesn't pass the sniff test, because in many cases, this might be the only defense that we have. And as you can tell, it has to be asserted as early in this process as possible before it's too late. If we ignore the Fifth Amendment active production doctrine and merely turn over the information in an effort to be cooperative with the government and to act as if we're in good faith, that's all well and good. But this would be all to the detriment of the taxpayer, because once the IRS has the documents in their possession and they have the smoking gun, the rest is off to the races. They then can build their case, refer it to CI, and the next thing you know, your client could be the target of a grand jury subpoena, or even a criminal defendant in an indictment. So it's so critical that we issue spot, and that we are on heightened alert for facts that might trigger a case like greenfield, so that we know when to appropriately assert the Fifth Amendment privilege against compelled document production. And in many instances, the existence and whereabouts of the documents requested are unknown to the IRS. And as I've cautioned before, it's really the rare situation in which any good can come out of assisting the IRS in a fishing expedition. When in doubt, always err on the side of caution and invoke the Fifth Amendment privilege. We have three situations that are ripe for raising this Fifth Amendment active production privilege as a defense in foreign bank account records cases. We've already discussed one, and that's in response to an IDR or a summons seeking information about offshore bank accounts. The second is, and might not be as readily apparent, but is during an IRS interview when the agent insists that they have third-party information that allegedly links your client to a violation of the tax code, but when you call them out on it or ask them specifically what that information is, they categorically refuse to disclose anything about the purported documents in their possession. So that might be another scenario ripe for the assertion of the privilege. And the third would be in response to a revenue agent's request to file past due international information returns to toll the meter from continuing to run on penalties. That's oftentimes what causes the taxpayer to react or to, by pushing their buttons and cautioning them that the meter on penalties will continue to run if they don't file their past due international information returns. And little do they know that the unspoken word is that once they make that knee-jerk reaction and file those past due international information returns, not only do they suffer a penalty, but the penalty becomes so overbearing that it basically wipes away their savings. So these are other scenarios, not as well known as the one we discussed before, but nonetheless where we can assert the privilege. And again, I can't overemphasize that audits of taxpayers who make quiet disclosures, and by quiet disclosure, we're talking about, simply going back in time and filing delinquent FBARs or delinquent international reporting forms, whether they be 8938s for specific foreign financial assets, or whether they be 8621 for passive foreign investment companies. Audits of taxpayers who quietly go back and file these delinquent returns, or who inappropriately enter into the Streamline program, these are ticking time bomb cases. The Streamline program is another voluntary disclosure program. It doesn't offer any immunity against prosecution, and the taxpayer could potentially have what's called their non-willful certification rejected by the IRS, in which case they are left with no remedy for coming into compliance short of just filing delinquent returns. And so this is risky business, and we have to be very careful and on guard all the time. One false step and our client could be doomed to spending a lot of time in solitary confinement if the case ever makes its way to the CI arm of the IRS and is referred to the Department of Justice. So even in the wake of Greenfield, the law is incredibly unsettled, and the IRS is doggedly determined to catch tax cheats. For these reasons, we as tax practitioners must always, be on high alert, and if necessary, if this is not an area of specialty that we have, reach out for a tax attorney who possesses the training and expertise needed to provide tactical and sound advice when it comes to invoking the Fifth Amendment privilege. Again, this is a very specific area of the law, and while we want to protect our clients' rights, we have to be careful because we cannot arbitrarily and randomly assert the Fifth Amendment if there's no good faith basis. And the travesty in so much of this is that, the tax professional, the tax practitioner, in trying to help the IRS and thinking that they're going to curry good favor with the IRS, turns the information over. In many cases, it was information that validly was protected or could have been protected if the privilege was asserted. And, again, that goes to why it's so critical to analyze this and see whether the privilege applies. So we have to remain vigilant at all times and not be timid and, not be weak-kneed when it comes to asserting these privileges, even when the IRS, is, putting us in an uncomfortable position and is, even, threatening us. We need to be very vigilant, and we need to always keep our client's best interest at heart. Now, if you have any questions about the presentation up until now, feel free to email me at the email address on the screen, or you can always contact me, and I'm happy to chat with you more